Chair recognizes Mr. Leach in opposition.
Thank you, Mr. Speaker. I'm going to leave this amendment to the will of the House. I'm going to be voting against it because Representative Krause's amendment to this bill has been vetted and drafted by some of the foremost religious liberty experts in the country. And we believe that the language is tight. I'm in compliance, and it's synonymous with other parts of state law. And so I'm going to allow the body to vote on this, but I'm going to be voting against it simply because I don't think
Mr. Speaker. Mr. Turner, for what purpose?
The gentleman yield for a question.
Yield?
Yeah, I
yield.
Thank you, Representative Leach. So I'm looking at Mr. Moody's amendment to your amendment, and I believe it is identical to the amendment that you just accepted on the previous sunset bill, is it not?
The difference in the sunset bills, the first one was with respect to application and admission to the state bar to be able to practice law, essentially regulating the Board of Law Examiners. This actually deals with the actual practice of law. The State Bar of Texas's rules on lawyers, which are adopted by the Supreme Court, relating to the practice of law, not the admission of law. That's the difference.
Well, I understand the difference in the bills, but in terms of the amendment, one was acceptable, and you're saying one is when you're going to oppose, but the wording of the amendment is identical. So if the same standards that were adopted in the previous amendment with Mr. Moody's language modifying your language, my question is why would they not be acceptable in this instance if it's the exact same language?
No, Representative Turner, that's a good question. In my mind, in the minds of other members who are counseling me on this, it's just different context. When you're talking about admission to the state bar and regulating the Board of Law Examiners and then actually talking about the actual practice of law, what lawyers can and cannot do, it's just a different context, which is why I accepted the first one, but I'm going to be actually leaving it to the will of the body, but voting against it on this bill.
Okay. And as you know, I'm not an attorney, so
congratulations.
I'm not as familiar. Yeah, thank you. I'm not as familiar with the state bar and its inner workings as you are. But has there been a problem identified in the state bar or just in the practice of law in general in Texas that this amendment, your amendment, would seek to solve? Because I've not heard of any.
Sure, Representative Turner, the American Bar Association this past summer, I believe it was in August, maybe early September, adopted and promulgated rules that caused concern in this area across the country, even here in Texas. And Attorney General Paxton, I believe in November or December, wrote an Attorney General's opinion relating to the ABA rules, essentially calling them, I believe he used the term unconstitutional. I don't have the word letter here, the letter in front of me, but I believe he actually called it unconstitutional. And so what this amendment will do is, with respect to the State Bar of Texas, the rules promulgated by the Supreme Court of Texas, regulating and authorizing the practice of law in the state, will ensure that the ABA rule is put to the side and that we're actually protecting the First Amendment freedom of religion rights of attorneys across the state.
And what was the ABA rule? I'm not familiar with it.
So, Representative Turner, it's ABA rule, Model Ethics Rule 8.4G, regarding attorney misconduct due to discrimination, essentially saying that what would constitute a violation of an individual attorney's rights under any applicable statute or constitutional provision. I can read the rule for you if you want me to, or if you want to come down here, I'll show you.
Can you summarize it?
Yeah, so essentially what it would do is it would define professional misconduct. And again, this is an ABA rule. This has to be adopted by the states regulating the practice of law. It hasn't yet been in Texas, but what this would do, Model Rule 8.4, subsection G, would essentially define professional misconduct for a lawyer to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status. It's essentially just expanding, the ABA is expanding the definition of professional misconduct.
Okay.
And what we're saying...
Which of those do you object to?
Representative Turner, all my amendment does is it protects, if you read the actual text of the amendment, it protects the First Amendment rights of lawyers in this state. It asks the Supreme Court, it directs the Supreme Court, which is in charge of promulgating our rules here in the state, it directs the Supreme Court to follow the Constitution and to abide by the Constitution, not to abide by some model rules promulgated by any voluntary association like the American Bar Association.
Okay, well, my question is, doesn't the First Amendment protect the First Amendment rights of lawyers in the state, and in fact protect all of us?
Well, Representative Turner, I certainly know what I believe. I believe it does, but I also believe that the American Bar Association, which is a voluntary organization which is essentially promulgating rules through the states, through the law schools, through lawyers across the United States, what the American Bar Association has done, I believe, and Attorney General Paxton believes, is unconstitutional. And so, yes, I believe the Constitution is clear. The Constitution is the rule book, not a guidebook or a suggestion book, but the American Bar Association seems to disagree. And so what we're doing by way of this amendment on the Sunset Bill is ensuring that the Constitution is followed, not the rules promulgated, model rules promulgated by the American Bar Association.
Right. Well, I would hope that our Supreme Court and any public servant, be they state bar appointees or judges or any of the rest of us, would always follow the Constitution, including the First Amendment, which protects our free exercise of religion. So
I would hope the same thing, Representative Turner. I'm glad we agree on that. But this amendment is belts and suspenders for any future Supreme Court that might be tempted to follow the American Bar Association rules, which are clearly unconstitutional.
And you believe that there is a risk that a future Texas Supreme Court would look to the American Bar Association and not the United States Constitution in its rulings, in its decision-making?
Representative Turner, yes, I do believe there's that risk. Stranger things have happened. We've seen it before. What we're ensuring is that the
when have we seen it
by the
before?
way, if you let me finish, the Supreme Court has, in some instances, adopted American Bar Association rules. They've taken the suggested model rules of the ABA and have used them to promulgate rules down to Texas lawyers. But in this area, as General Paxton said on December 20th, 2016, this rule is clearly unconstitutional. And therefore, we as the legislature, not the Supreme Court, the legislature should be providing guidance in this area, and that's what we're doing by way of this amendment.
And you're saying that the court has adopted rules in the past that have violated the U.S. Constitution? I mean, I think that's if the Texas Supreme Court has adopted rules in violation of the U.S. Constitution, I think that would be big news. And I'm wondering what that is, what they've done that violated the Constitution.
Representative Turner, the state Supreme Court, our Texas Supreme Court, in the past, now, and in the future, no matter who's on the court, the legislature has authorized the members of that court to prepare, propose, and to adopt rules governing the state, the practice of law in the state. The legislature has given that power to the Supreme Court, not the other way around.
I understand.
So every so often...
What have they done that's violated the Constitution?
Every so often, this body comes together and directs the Supreme Court. Otherwise, sunset review for the Supreme Court and the state bar wouldn't be necessary. And so when we see the American Bar Association proposing rules that the Attorney General has described as potentially unconstitutional, we have, as the legislature, have an opportunity to put belts and suspenders on, and that's what this amendment does, Representative Turner.
Okay. So we're not aware of any examples where they violated the Constitution before, but we fear that they may violate the Constitution in the future, but passing a law, they might ignore the Constitution, but they'll certainly obey the law. I mean, is that the logic?
Representative Turner, perhaps I misspoke. My intent and Representative Krause's intent by way of this amendment is specifically targeted at this area, which there is disagreement among the circuit courts and even among Supreme Courts across the state, federal and state, as to what this area of law, what the First Amendment means, what it protects, what it doesn't protect. And in Texas, when we saw the ABA come down with this model rule, we have an opportunity this session. It just so happened that we're under sunset review for the state bar this session, and so we saw the model rule, and we want to ensure that the state bar and that the Supreme Court does not go by way of the ABA, but make sure that it's faithful to the plain text of the Constitution.
Okay, well, I still haven't heard what they've done in the past that's unconstitutional, why what they might do in the future would be unconstitutional, what the Attorney General thought was unconstitutional about the ABA rule, and I still haven't heard why the First Amendment doesn't already cover this. But thank you very much,
Representative
Mr. Leach.
Turner.